Julian, thank you very much. It's so very rare that anyone says anything nice about you in state politics, so it's a lovely thing to hear. I'd also like to thank Ron Manners and the Mankale Foundation for their support of this evening, and that's an organisation that has a great deal of lobbying and activist work with respect to market liberalism and economic matters, and it's lovely to drag Ron into the social policy field, at least for one evening, and I thank him for his attendance tonight and his assistance with this launch. And of course, the large launch, very large launch for this publication occurred in Sydney very recently, and Julian is travelling around in each of the capital cities where there'll be somewhat smaller launches. But I, in fact, recall the Republican debates going back many years now, and at that time, in fact, my mind was rather undecided on the issue, and I went to several gatherings, and they looked very similar to the gatherings of this room this evening. Small groups of very interested people who went and spoke outside the rooms and made decisions which in the end changed the face of the nation and may well do again. Julian, again, thank you for mentioning the debating years. I was a very funny debater, but I've also completely lost the ability to be humorous after 7 months in state politics, so I hope that you're not going to be expecting any jokes. What I thought I would do is give a few very simple observations about rights documents as they have been discussed in this book, and I think should honestly and openly be discussed over the next 8 to 12 months before this issue comes to a head. And if I could just put those comments against this backdrop, and it's a backdrop about, it's a very difficult way of putting this, and the only way I can think of is that being a bit of a nerdy person, I love science fiction, and quite often you will go on websites and science fiction devotees will say, what if you could have any superpower, what would you have? Would you be Invisible Man? Would you have incredible strength? Would you be immortal? What would it be? Obviously I need to get out more, but that's the sort of thing that I'm interested in. And I came to thinking, if I were in public policy, in politics, in liberal democracy, what is the one power that I would want? What is the one power above all others that I think is enormous? And I, on reflection, think that I would choose the power of interpretation. If you had the power to determine in an authoritative and binding way what a person or body actually meant in practical terms of outcomes by what they said or what they wrote, I think that is the single greatest power in liberal democracy. And of course, in a liberal democracy, we have engineered a system where the courts are the central repository of that power of interpretation. But in recognition of the sheer scale of that power, we've been very careful over hundreds of years to limit the court's ability to engage in that interpretive activity. And we've done that through having very well-known rules of interpretation, through 100 years of courts binding themselves by their own decisions about what a word or a phrase will actually mean when it's used in one or either context. So, if you like, courts are like Phar Lap. They are, without question, the most powerful and strongest in the field, yet over 100 years we've severely handicapped them in a range of quite proper ways, and ways which the judiciary have long accepted. So it's against that backdrop that I'll just make a few brief observations about rights documents. And one of the observations is that the debate that is growing up around rights documents is absolutely intriguing, because it takes on this new flavour where the assertion is that the merely declaratory nature of the rights documents that are now being debated and envisaged is such that they exhibit one particularly desirable quality, and that is that they're not in any real or meaningful way going to diminish parliamentary sovereignty. And that is the claim that you will hear over and over and over again by the advocates of declaratory rights documents. And I think that that is an adversarial tactic. It's a tactic of argument, because what it's meant to do is sidestep what is, without doubt, in my view, the most powerful argument mounted against such documents, and that is that they diminish parliamentary sovereignty, that they have public policy decision-making placed in the hands of the judiciary. And in so doing, they exhibit strong anti-democratic tendencies. I'll also note this: it's a very clever tactic of advocacy, but it does leave the proponents and advocates of bills of rights with something of a logical hole, because arguing in favour of legislation by a suggestion that it deliberately has no effect, even in my short time in Parliament, has proved to be a very difficult thing to do. And you will note now that the advocates of bills of rights and declaratory bills of rights will talk about their soft effects, educative, community-based effects. Whenever I hear those words in Parliament, I always think we've won the argument, because if you can't point to what it actually does, then you've got some troubles to start off with. But it's all smoke and mirrors in any event, because they do an enormous amount, in my view, or will do if they're instituted in this country. I just want to read to you a short paragraph that came out of the Western Australian Human Rights Act report of the Consultation Committee for a proposed WA Human Rights Act. And my predecessor embarked on a process of consultation not dissimilar to the one that's going on at the moment. And as a new and young Attorney-General, when you are strolling the rooms of your new departments, you will find unusual things, such as thousands and thousands and thousands of these documents piled up in plastic wrap, because it went no further, because sensible members of the Australian Labor Party saw that it wouldn't go further. But the committee said this: the committee has given careful consideration to Professor Craven's arguments, which were reflected in a number of submissions which were opposed to the government's proposal. However, we find them to be at odds with the actual content of the draft bill. Arguments about shifts in the balance of power in favour of the courts and the courts being able to overrule Parliament are arguments that have been developed in relation to constitutional bills of rights, such as that in the United States. These arguments appear to have simply been transposed into dialogue-based human rights acts, despite the fundamental differences between the two models. As noted by the Commonwealth Human Rights and Equal Opportunity Commission, one of the most frequently cited arguments against human rights acts is that they transfer power to an unelected judiciary. However, in the context of a dialogue model of human rights protection, this criticism is misconceived. So without question, the most serious, honest and fundamental argument about declaratory rights documents, or any rights documents, that they move public policy making power from the Parliament to the judiciary, is neatly sidestepped by saying, don't worry, declaratory rights documents don't have any effect on the Parliament whatsoever. And the basis for that assertion is twofold. One is that because declaratory rights documents only empower the courts to declare any given act of Parliament as inconsistent with the right, but they don't invalidate it, they don't strike it down. And secondly, that all they do is require courts to interpret existing legislation in accordance with rights, which are often, as Julian pointed out, very vaguely drafted. So the formula that you will see throughout the debate in favour of bills of rights documents is this, simply put: declaration plus interpretation equals dialogue, but it does no harm to Parliament. Now, I think that that is a fundamentally flawed and genuinely dishonest argument. And to my way of thinking, it's bad enough, if you like, the idea of federal courts telling the federal parliament how to go about its business. But the idea of federal courts telling our state parliament how to go about its business sends truly shivers down my spine. And I can say quite unequivocally, if this ever did come to pass, that I would be advising my cabinet very strongly, perhaps even aggressively, that we should mount a constitutional challenge on the basis of Boilermaker principles and others, that this legislation is unconstitutional. And that challenge would look something like this. It has long been held by the High Court that courts, federal courts, can only do one thing, and that is be courts. They can only determine clear rights in dispute between individuals in a determinative way. The whole idea that the High Court would have a declaratory power is something completely foreign to the High Court itself. And there's no doubt, in my view, that these documents would be ruled unconstitutional. But the irony, I think, is this, is that I would advise mounting a constitutional argument against the documents because courts should not be declaratory, federal courts in nature. But it's not the declaratory function that would actually do all the damage, it's the interpretive function. And I just want to leave you with one example, and it's one that appears in the short chapter that I contributed to this book. But people who say that the interpretive function, again, is harmless, they will say, don't worry, we only let courts interpret legislation when there's ambiguity. And let me assure you that in my experience as a lawyer, ambiguity is everywhere. Absolutely everywhere. And let's use this example, which I think is a very good example, and that is the case of RJE, which was a Victorian Court of Appeal case which dealt with an appeal against an order made pursuant to Section 11.1 of the Serious Sex Offenders Monitoring Act 2005. Now, I'm going to talk about this case very briefly. I break a promise to all my staff who have said never talk about case law in speeches. People's eyes glaze over and it's very boring, but I assure you this is an exciting case. It was a case, as I say, about the Serious Sex Offenders Monitoring Act. That, in effect, is an act not dissimilar from an act we have here, which does something very, very serious. It allows a court to determine that someone should be held in detention past the expiry of their sentence in circumstances, particularly with a sex offender, where they think that they are likely, if they are released, even though they are due to be released, they are likely to commit a further offence. Now, this is very, very serious legislation, and people in this room, and indeed people who are against a rights document, might have various views as to the wisdom of that legislation. But it's legislation that's been produced by intensive consultation by and from democratically elected parliaments. Now, the appeal decision, revolved around the word likely. And likely is one of those words in common English usage which we all think we know what it means, but let me assure you, you don't. Because it can mean likely as in balance of probabilities, that something is 50 plus 1% likely to occur, or it can mean likely as in there is a real rather than remote chance, which might mean 20% likely to occur. For 100 years in Victoria, it had been the case that appellate decisions had determined that likely, in the context in which it was being used in this legislation and similar contexts, meant a real rather than remote chance. It meant something like 20%. In this case, activating the interpretive requirements of the Victorian Declaratory Charter of Rights, the court said this. It said, for the first time ever, because we are required to interpret this word, in light of this new legislation, we will change the meaning of the word. And let me read to you what they said. The court commented that although Parliament's intention had presumably been in line with the previous interpretation of the word likely, and I'll quote now, to adopt now the construction which the court prefers is to accept that the intention of Parliament has changed. That seems strange, but it appears to be the way in which the Charter was intended to operate. Now, presumably when Parliament drafts using a word like likely, when I say I presume, I know because I do this, I know what the word likely means. Linguistically, it is open to interpretation, but legally, because of precedent, we know what it means. All of a sudden, we take the weights off Phar Lap and allow that horse to have unbridled superiority through the power of interpretation. I think that that is an enormously dangerous development. Through these interpretive clauses, you'll have a word which was previously ascribed a legally unambiguous meaning through precedent, and at once it becomes, by virtue of the rights document, reclassified as ambiguous and redefined in a manner quite contrary to the way in which Parliament uses the word in its legislation. And the effect is to completely change the intent of Parliament and the effect of the legislation. I told you it was an exciting case. I'm glad that you bared with me to realise that it was. But it's one of many, and there are 3 or 4 examples that appear in my contribution to this book, and there are many more out there, ways in which rape shield laws have been reversed, where a Parliament has intended that a presumption be applied which says that we presume the person knew that they had the drugs, reversed because of declaratory rights documents, any number of examples. So whatever views you might have about the wisdom or unwisdom of the legislation itself, let me tell you that you won't be getting legislative effect from Parliament if you have a bill of this type, a declaratory rights charter. You'll be getting it from the courts. And the overwhelming problem with that, I think, is not merely that we subvert Parliament's intention, but that the courts, in becoming policymakers, won't have to put up with all the nonsense that I do. They will, for the first time, have to have people marching on the court demanding policy outcomes, something that we have humanely been spared over the last 100 years. So if you want to see an American-style court, then a Charter of Rights is for you. But if you like the balance that we have at the moment, then I would suggest that you read this book and form your views. Julian, you have my warm congratulations. I also found you an enormously entertaining debater, not as funny as me, but very good. And I give you enormous congratulations because you've done a wonderful thing in compiling such a book with such diverse contributions, and well done.